Welcome to our new video. Today we are going to discuss some important and interesting topics under copyright law in India. From joint authorship to musical works, sound recordings, and what qualifies as an Indian work, this video is packed with clear and easy explanations. So let's dive right in. What is meant by work of joint authorship under copyright? A work of joint authorship refers to a creative work that is produced by the collaboration of two or more authors, where each contributor plays a role in creating the final work. The key characteristic of joint authorship is that the contributions of the authors are inseparable or interdependent, meaning the work cannot be fully attributed to one author alone. The authors must have worked together with the intention of creating a single, unified work. Key features of a work of joint authorship. 1. Collaboration of two or more authors. A joint work is created when two or more authors collaborate in the creation of the work. The authors may be from different fields, have different skills, or contribute in different ways, writing, drawing, composing, etc. The authorship of the work is shared, meaning no single author can claim exclusive rights over the entire work. 2. Inseparability of contributions. The contributions of each author in a joint work are interdependent, meaning the individual contributions are so intertwined that they cannot be separated or distinguished from one another. For example, in a novel where one author writes the dialogue and another author creates the plot, the contributions are inseparable, making it a joint work. 3. Intent to create a unified work. There must be intent among the authors to create a single, unified work. This is crucial in distinguishing joint authorship from works created separately by multiple individuals, where each person retains independent rights to their contribution. Examples of joint authorship. 1. Books. A novel written by two authors, where one author writes the plot and the other writes the characters' dialogues. 2. Music. A song where one artist writes the lyrics and another artist composes the melody. 3. Movies, films. A film screenplay written by two or more writers, where each contributes to different aspects of the script, such as dialogue, storyline, and character development. 4. Art and graphic design. A collaborative art piece where one artist creates the background and another creates the figures or details. 5. Research papers. A scientific or academic paper written by multiple researchers, each contributing different parts of the research or analysis, resulting in a single collaborative work. Rights of joint authors. Ownership of copyright. In a work of joint authorship, the copyright is typically shared equally unless agreed otherwise. Each author has the right to use, license, or distribute the work, but this is subject to the agreement between the co-authors. Moral rights. Each author retains moral rights over their contribution, which includes the right to attribution and the right to object to derogatory treatment of the work. Exploitation of the work. Any author may not use the work independently for commercial purposes unless agreed upon by all the joint authors. If one author decides to use the work for commercial gain, e.g. licensing, they may need to seek the consent of the other authors or share the profits. Important considerations for joint authorship. 1. Agreement between authors. It is highly recommended that joint authors have a written agreement that outlines the rights, responsibilities, and revenue-sharing arrangements regarding the work. This helps avoid disputes over ownership and usage. 2. Distinct contribution. If an author's contribution to the work is separate and distinct from others, e.g. one author contributes only illustrations to a book while the other provides text, it might be better categorized as a work of authorship with contributions, rather than joint authorship. In such cases, the authors may have separate copyright ownership of their respective contributions. 3. Duration of copyright. The copyright in a work of joint authorship generally lasts for the lifetime of the last surviving author, plus an additional 60 years. The duration may vary by country. What is a musical work under copyright? A musical work refers to a composition of music, which can include both the melody and the harmonies, typically not involving any lyrics or performance aspects. It is a musical creation that stands independently from any performance or recording of the music. Key components of a musical work. 1. Music. The musical work itself refers specifically to the musical composition, which includes the melody, the main tune, harmony, the chord structure accompanying the melody, and rhythm, the timing and beats. This is what is written or conceptualized by the composer, and it focuses on the musical elements of the piece, how the music sounds. 2. Graphical notation. A musical work can be written down in sheet music or notation. This includes musical scores that visually represent the musical composition through symbols like notes, rests, and clefs. Musical notation is an important part of the work, but it is not limited to this. A musical work can be in the composer's mind or played by ear without being written down and still enjoy copyright protection, as long as it is original and fixed in a tangible medium. 3. Excludes words and performance action. A musical work does not include lyrics or words that are sung or spoken with the music. These would be considered a separate category, specifically covered by lyrical works or dramatic works. It also does not include the performance of the music itself. While the musical composition is protected, the performance, such as a concert or recording, is separately protected under copyright as a sound recording or performance rights. 4. No requirement to be written down. A musical work does not need to be written down or recorded to enjoy copyright protection. The moment the work is created and fixed in any tangible medium, such as a recording, score, or even as a conceptual idea fixed in the mind of the creator, it is protected. This means that even if the music is only in the composer's head or played but not written down, it can still be eligible for copyright protection once it's fixed in any form, such as an audio recording or notation. Examples of a musical work. 1. A melody or tune that a composer creates, which exists on paper or in the composer's mind. 2. Sheet music that shows the notes and rhythms for a piece of music. 3. Classical compositions such as Beethoven's Symphony No. 5 or Mozart's Eine kleine Nachtmusik. 4. A song's melody and harmony written by a composer, even before the lyrics or performance are added. 5. A musical score for a film or musical, excluding the lyrics or the vocal performance. Key points to remember. A musical work is protected separately from its performance or sound recording. For example, a song's melody can be copyrighted as a musical work, while a recording of that song, such as a CD or streaming version, has a separate copyright. Musical works can include a variety of genres, from classical compositions to contemporary music, as long as the music is original and fixed in a tangible form. Lyrics and performance are not part of a musical work for copyright purposes, but are separately protected, e.g., lyrics are considered a literary work, and a performance is protected as a performance right. Copyright protection for a musical work typically lasts for the lifetime of the author, plus 60 years, after which the work enters the public domain. For more detailed information, visit the official website of VMK Professionals, wvmpaypros.com, and always review the latest amendments before execution, as laws keep changing frequently. What is sound recording under copyright? A sound recording refers to any recorded work where sounds are captured in a format that allows those sounds to be reproduced, played back, or transmitted. This includes various types of recordings, from music albums to sound effects, and it can be captured on many different types of media, such as tapes, CDs, digital files, and more. The key here is that a sound recording is an embodiment of sound that can be reproduced and played back, regardless of the method or medium used. Key characteristics of a sound recording. 1. Capture of sounds. A sound recording captures sound in a fixed medium. The sounds could include music, speech, spoken words, ambient sounds, or sound effects. These sounds are recorded in a way that allows them to be reproduced. The recording itself is not about the composition or lyrics, but about the fixed version of those sounds as they were originally recorded. 2. Medium and method of production. A sound recording can be created on various mediums, such as vinyl records, magnetic tapes, CDs, digital files, MP3s, waves, and even streaming audio formats. The method of production could involve technologies ranging from analog recording equipment, like tape recorders, to digital recording methods used in modern studios or even home recording setups. 3. Phonograms and CDs. A phonogram is another term often used to refer to a sound recording, particularly in the context of copyright law. It specifically refers to the physical medium, like a vinyl record or cassette tape, in which sound is recorded. A CD-ROM, compact disc read-only memory, is a form of sound recording if it stores audio data. However, in this context, CD-ROMs are typically used to store audio recordings, not software or data, which makes them part of sound recordings when they contain music or spoken content. 4. Independence from the underlying work. A sound recording is distinct from the musical work itself. For example, the musical composition, melody, harmony, and lyrics is a separate work from the sound recording, the actual recording of the music played by musicians or singers. Copyright in a sound recording protects the actual recorded version of the music or sounds, while copyright in a musical work protects the composition of that music. Examples of sound recordings. 1. Music albums. A CD or digital file containing a collection of songs is a sound recording. Even though the music is a composition, the actual recording, the way it was performed and recorded, is protected as a sound recording. 2. Audiobooks. When a book is read aloud and recorded, such as an audiobook on CD or in a digital audio file format, e.g. MP3, this recorded version of the book is a sound recording. 3. Podcasts and radio shows. Any podcast or radio show that involves spoken words or discussions recorded and made available for playback is considered a sound recording. 4. Sound effects. Recorded sound effects, such as the sound of waves crashing or the noise of footsteps, captured and used in film, television, or video games, are sound recordings. 5. Spoken word recordings. Recordings of public speeches, interviews, or lectures, where the content is spoken and recorded, fall under sound recordings. Important points to remember. 1. Protection of sound recordings. Copyright in a sound recording protects the specific recording of the sounds, including how they were arranged, edited, or performed. This is separate from the protection of the underlying musical composition or lyrics. 2. Duration of copyright. In many jurisdictions, the copyright in a sound recording lasts for 60 years from the date of the recording's publication, though this can vary depending on the country's laws. 3. Fixation and reproducibility. The key element of a sound recording is that it is fixed in a medium from which it can be reproduced or played back. Without being fixed, it would not qualify for copyright protection. For example, a live performance, unless recorded, is not considered a sound recording until it is captured in some form, e.g. via audio recording. 4. Distinction from other works. While musical works, like a song's composition, and literary works, like a spoken poem, are separate categories under copyright law, the sound recording is an independent work. It does not necessarily need to involve music or lyrics. Any captured sound qualifies. What is an Indian work? An Indian work is defined under Section 2 of the Copyright Act 1957 and can be understood through the following key criteria. 1. Work created by an Indian citizen. If the author of a work, literary, dramatic, or musical, is a citizen of India, the work is considered an Indian work. This holds true regardless of where the work is published or distributed. 2. Work first published in India. If the work is first published in India, it qualifies as an Indian work. It does not matter if the author is from another country. The crucial point here is that the first publication happens within the Indian territory. Unpublished work of an Indian citizen. In the case of an unpublished work, if the author is a citizen of India at the time the work is created, it is considered an Indian work, regardless of whether it has been published or not. For example, a novel written by an Indian author, even if it is unpublished, would qualify as an Indian work. Key points to note. 1. Types of works covered. An Indian work includes literary works, dramatic works, and musical works. This covers a wide range of creative and artistic productions like books, plays, music compositions, and other similar works. 2. Citizenship of the author. The nationality of the author plays a crucial role in determining whether a work is an Indian work. If the author is an Indian citizen, the work automatically qualifies as an Indian work, even if it is created outside India. 3. Place of publication. The place where the work is first published is also important. If a work is first made available to the public in India, it is considered an Indian work, regardless of the nationality of the author. 4. Unpublished works. Even if a work has not been published, it can still be considered an Indian work if the author is an Indian citizen at the time of creation. This is significant because the Copyright Act offers protection to unpublished works as well. If you want to register a copyright for your work, contact VMK professionals today. We'll help you protect your creativity with a smooth and hassle-free process. Visit www.vmkpros.com or call us now to get started. And that's it for today's video. We hope you learned something new about joint authorship, musical works, sound recordings, and Indian works under copyright. If you found this video helpful, let us know your thoughts in the comments section. Don't forget to like, share, and most importantly, subscribe to our channel for more easy and informative legal explainers. See you in the next video.